When you buy an item at a store, you usually walk out of the store with the purchased item in hands. But that's just not the case for everyone when it comes to purchasing a firearm here in Florida. As a result, the National Rifle Association has filed another federal lawsuit here in Florida seeking to do away with Florida's cooling off period for purchasing a firearm. Hello everyone and welcome to the Firearm Firm channel. I'm attorney James Phillips, a practicing Second Amendment and self-defense attorney, and today we're going to be talking about NRA's newest lawsuit in the Sunshine State. This week, the NRA, along with several named plaintiffs, including a gun store, filed a federal lawsuit in the Middle District of Florida seeking declaratory and injunctive relief against the Commissioner of Florida's Department of Law Enforcement, Mark Glass, Florida's Attorney General James Uthmeyer, and 3 different named state attorneys. Now, I'm not really sure why the NRA chose to file in the Middle District of Florida, as that is the same district that ruled against them in the lawsuit concerning Florida's 18 to 20-year-old ban on purchasing firearms. I'm also not sure as to why they chose the 3 different named state attorneys that they chose, but I assume they have their reasons. Now, looking specifically at the complaint, the NRA is challenging the constitutionality of Article 1, Section 8B of Florida's Constitution, which was added to the Constitution in 1998, and Florida Statute 790.0655, which was enacted in 2018. Article 1, Section 8B imposes a 3-day minimum waiting period from purchase and delivery on all handguns purchased from a federal firearms licensee, an FFL, with certain exceptions. Those with the valid CWFL and those trading in a handgun for another handgun are exempt from the 3-day waiting period. In 2018, Florida Statute 790.0655 became in effect, and it expanded the 3-day waiting period to include the purchase of a long gun, so a shotgun or rifle. And again, this had very few exceptions. Anyone violating the 3-day waiting period can face criminal prosecution. The NRA alleged in the complaint that because the cooling off waiting period provisions prevent individuals from possessing bearable arms for a period of 3 days, conduct that the Constitution presumptively protects, the plain text of the Second Amendment is implicated. Plaintiffs have met their burden under Bruin, and the cooling off waiting period provisions are presumptively unconstitutional. The complaint goes on to read, since the Second Amendment presumptively protects plaintiffs' conduct, the state must justify the cooling off waiting period provisions by demonstrating that they are consistent with the nation's historical tradition of firearm regulation. They go on to say it is impossible for the state to meet this burden because there is no historical tradition of firearms being regulated in this manner, either at the time of our founding and the ratification of the Second Amendment or during the Reconstruction era and the ratification of the 14th Amendment. In fact, according to the complaint, the first waiting period law was not enacted until 1923, and it involved a 1-day waiting period for handgun sales in California to provide more time for background checks to be conducted, a process which is nearly instantaneous today. I definitely look forward to seeing the state's response in this case, and I will be keeping a close eye on this case as it moves through the judicial system. Be sure to let us know what you think about this lawsuit and Florida's mandatory 3-day minimum waiting period down in the comments section below, where you can also leave any questions you have about the Second Amendment or any other self-defense related question. Until next time, stay armed and educated.